Hello, Professor Warren Barr here again. I'd just like to talk about a corpus of research really that I've been doing over the years into housing and the role of charities in housing. And as I said, I think before, this started probably from a doctrinal look at how difficult it is for charities to actually grant occupation rights to people in law that they want to. And without going into tedious amounts of legal detail, really in English law there are two choices. There's a tenancy, which is a property right which is protected, and particularly for charities working in the housing sector, there are particular protections on tenancies which come through legislative involvement from a variety of different housing acts. And then there's the licence, which is supposed to be a much more temporary form of accommodation. And what got me interested in this area is it's actually quite difficult now to grant licences in general law, simply because for a number of years in residential lettings, in other words, lettings to people who want to live in a home, landlords were trying desperately to avoid granting tenure or leases to people to give them rights, and were instead granting licences for only one reason, not that they really wanted to or understood what they were doing necessarily, but because there was something called Rent Act protection, which meant that if you had a tenancy rather than a licence, you were Rent Act protected, and it meant that landlords could only charge a certain amount of rent. There was a ceiling, if you like, a maximum price on rent. Because of that, they sought, through devious means, to turn what would have been leases in law into licences. And the legal response to that was twofold, and it's one of those interesting areas in law where you have the judiciary do something, and just about literally days afterwards, Parliament intervene. And Parliament passed the Housing Act 1988, which came into effect in 1989, and that got rid of rent control effectively for new tenancies. But before that, a pivotal case, which all law students and most practitioners would be aware of, Street and Mountford, Lord Templeman in the House of Lords gave a judgment changing the whole basis of the rules upon which one distinguished between a lease and a licence. And he said, really, it was the fact of what was granted that mattered. And there's a wonderful metaphor about forks and spades, which, again, is well known. But essentially what he was saying is, no matter what the agreement said, it was up to the courts and those who were interested to look behind the agreement and see what in substance was granted. So that clauses like someone couldn't use the property between certain times, which were inserted purely to avoid giving this tenancy right, were to be struck out, and you would look at things and say whether it was a lease or a licence. Nice paternalistic approach. Unfortunately, and what got me interested, was that wasn't necessarily of much use to charities, because charities might actually be accommodating people for a variety of reasons. Within their own charitable purposes, they might need to house someone temporarily because they're homeless or because they're in financial need, but that position can change. And if they've granted someone a tenancy, there can be all sorts of difficulties in allowing that person to leave. That then went, so there was an article published on that, charitable lettings and their legal pitfalls. Moving on from that then into what led to the ASRC project on housing the mentally vulnerable is, how does that work across the scheme? There are certain rules and regulations. Were charities aware of not just their duties to their clients, but also the effective management? It's all very well for a charity or a charity trustee or someone housing someone to look at an individual and think, okay, you need X and I want to give you the best type of agreement, type of occupation arrangement I can. But they have to look beyond that, because as we know in law, charities are not for named beneficiaries, they're for charitable purposes. So you need to look at, as a charity trustee in that situation, you need to look beyond the needs of an individual and look at the management needs of all individuals who might benefit. So, for example, giving someone too much tenure, too many rights, might preclude someone else who needs that property from moving in, because you might not be able to move them on. So that's really what the crux of the Housing the Mentally Vulnerable project was about where charities involved, and one of the findings was that they didn't necessarily understand the legal arrangements, nor did they necessarily make those decisions in the best interests of the charity as a whole, rather than individuals. And then that led to another piece of work, which was looking at, well, what happens? Because one of the reasons charities, as you might expect, are very keen to give extreme numbers of rights, to give leases to people, is because they want them to have rights to stay there. They don't want people to move on. These are people living in homes in most cases. People don't like being evicted from their home or moving every few years, certainly if it's not by choice, but by necessity. So this was looking at, well, what happens when charities actually do have to intervene with either problematic tenants or people who have outgrown the needs of a particular charity. And that horrible word, because it is a legal term, eviction. And really what I was looking at was whether in charitable speak, eviction shouldn't be seen as something terrifying. It may actually be a necessary evil, if you like, to move someone on to a better service. And in fact, eviction in the charitable sector and the social housing sector has a different meaning in practice than it does in legal terms, which is simply that your arrangement would terminate and you'd be left homeless. Because in fact, there are a lot of duties and a lot of cross-sharing of practice where charities will use eviction to move someone on, and they'll only evict if the person or persons involved can be housed somewhere else in a better way. So again, it was looking at that sort of issue. So as you can see, from just one corpus of research and from one little idea, a whole series of things arises, and it's a piece of work which I could continue long into my career. Happily, it's not only me who's interested in these sorts of things, and I'm extremely pleased to say that I'm currently supervising a PhD student, Malavai Hood-Friedrichsen, who's looking into this, and in particular the impact of local policy changes in the last few years on housing entitlement for those in particular need. And without stealing his thunder, what he's particularly looking at is this idea that the deserving poor, which is a concept, a familiar and unfortunate concept, familiar from the Victorian age, might be creeping back into housing allocation perniciously through the way in which legislation is viewed and the way policy is building up around it.